Yes, proceed.
So I'm now going to address you on the improper purpose arguments. The improper purpose grounds of appeal are set out at grounds 5 and 6 of the claimant's grounds of appeal. That's in tab 1 of the core bundle at page 16. Ground 5 is that the judge erred in concluding that the exercise of the power of appointing the defendants was for a proper purpose, and such a conclusion was not open to him on the limited materials available, and such a conclusion involved an error of law in confusing the incidental effect of the exercise of a power with its true and predominant purpose. And ground 6 is that the judge erred in law in holding that an implied term restricting the exercise of the power of appointment of the type described by the Supreme Court in Braganza did not arise in connection with the exercise of the power of appointment in this case. In fact, this was a paradigm case of the implication of such a term. It can be seen that both grounds of appeal appeal the judge's rejection of the claimant's case, which was advanced below, that the appointment of the joint administrators was void because Niven had not exercised its power of appointment for a proper purpose. However, the claimants now argue in their appeal skeleton at paragraphs 39, 3, 40 and 41, you might want to just turn that up. That's tab 3 of the core bundle, page 39. So paragraph 39.3, the circumstance in which that request for information was made indicated strongly that it was not made with a view to the protection of the chargee's rights as lender. There was strong evidence to show that such rights were not considered to be under threat. On the contrary, the purpose was to engineer an argument that there was a technical breach of the information provisions so as to facilitate the acquisition of the business of Glint by Mr. Ferguson or one of his entities. And then if we just look at paragraph 40 and 41 of the skeleton argument, the judge only arrived at the contrary conclusion by mischaracterising the case that Glint advanced. See what amounted to a caricature of that case, and failing to identify the proper purpose for the exercise of the power contained in the information provisions. Had he focused on whether the request was for the purpose of protecting the chargee's rights as a lender or for the purpose of preserving its security, the judge ought to have concluded that it was strongly arguable that that was not the purpose. However, even on his own approach, the judge's analysis was flawed. He concluded in this case it was similar to one category referred to in re Artie Brightbar, which was actually a paragraph 80 case, and specifically was one where the chargee's intent was to enable an independent office holder to take control of the assets. So, in the skeleton argument, focus is also placed on whether the request for information was made for proper purpose. And so, although there's no ground of appeal that the judge should have held that the information provisions could only be invoked for a proper purpose, I will address you on that point, and also...
Well, indeed, and of course that's consistent with what my Lady Justice Falk said when granting permission to appeal, because she noted that the skeleton argument was attacking both and granted permission on that basis.
So dealing with grounds 5 and 6 of the grounds of appeal first, and the power to appoint joint administrators, the claimants seek to draw a parallel between the equitable good faith restrictions on a mortgagee's powers and the power to appoint administrators. We say that that attempt to draw the parallel is wrong and misconceived, because the equitable good faith restrictions on a mortgagee's powers apply only to their powers of enforcement. And that's for good reason. Mortgagee's powers directly affect the proprietary rights of the company, in this case, by appropriating property which would otherwise be in the control of the company. of the other. And that is different, we say, from the appointment of joint administrators, because that does not result in the appropriation of property into the control of the debenture holder or mortgagee. The property remains under the control of the company, with the joint administrators acting as agents of the company. Now,
why is that different to a receiver? Does the receiver act as agent of the company?
Well, yes, it does, but I'll come on to this. With a receiver, a receiver is under a duty to realise assets for the purposes of repaying the debt. But so it's essentially, although the receiver is an agent of the company, it's an agent only for the purposes of realising the assets for the purposes of realising of debt. With joint administrators, their agency is at large, if you like. They are proper and full agents, and their purposes are actually not necessarily to realise assets for the purposes of repaying the debenture holder. On the contrary, as we know, and we'll look at it in a minute, paragraph 3A requires the administrators as a first obligation, duty and function to seek to rescue the company as a going concern.
Sorry, can I ask a different question?
Yes.
Because what you're looking at here is whether it's mortgagee, administrators, receivers. You're focusing upon what they do after appointment.
Yes.
Whereas my understanding of the focus of the appellants tag is that they are looking at what precedes the appointment, not what happens after the appointment. So I'm struggling to understand at a sort of fairly elementary level what the relevance is of considering what constraints there may be on the powers of administrators after appointment.
Well, because where a debenture holder appoints an administrator, they effectively can't have. I mean, maybe this is an argument that I'm going to come on to later, but there is no possibility, whatever their subjective purpose might be, that they can, in fact, by the appointment of an administrator, effectively acquire the assets for themselves, as opposed to having as their primary purpose the repayment of their debt. Once, by electing to appoint joint administrators, they are actually electing to effectively give the possibility of their being able to acquire the assets. They are effectively giving that over to the joint administrators, and it's entirely a matter for the joint administrators within the confines of the statute as to how they perform their duties.
Right. Now, that is a point I can understand. So, putting it in my own words, and forgive me for the inaccuracy with which I'm about to phrase it, but bear with me. What you're saying is that the appointment of administrators as independent office holders insulates the effect of their appointment from any improper purpose that might have animated the person appointing.
That would be another way of putting it. And
but can I return to the
Yes.
first question I was asking, because I can understand the logic of what I've just summarised, but I still don't understand, even on that basis, how it is relevant to consider what constraints there might be on administrators in the exercise of their functions. Because the key point here, it seems to me at the moment is the fact that they're appointed under a statutory scheme, they are independent office holders, and therefore the animus of the person appointing them is irrelevant on this theory.
Well, yes, essentially. The person appointing the administrators, I suppose, could have the utterly misconceived animus that by appointing joint administrators they were going to achieve their purpose, namely but if they had properly understood the statutory mechanism, they couldn't have possibly had that animus, because administration and administrators cannot, simply by virtue of being appointed by a floating charge holder, then offer the assets for sale and the floating charge holder be able to acquire them.
But take a case of a lender who does have that belief that by doing this they'll engineer an acquisition of the assets themselves. But turns out they're wrong, because actually the company can just refinance and repay the debt, and that pulls the whole thing down.
Yes.
That's a classic case, isn't it, of a lender who thought they might be able to achieve something by appointment. In fact, they couldn't achieve it.
Yes.
But why would that prevent, why did the fact that happened, and in a sense, objectively was always going to happen?
Yes.
Why does that defeat the possibility that the appointment was for an improper purpose?
Because I think objectively it has to be the fact that the appointor has a purpose. If that purpose cannot, simply by appointing the joint administrators, be achieved, then it cannot be regarded as an improper purpose. Has to be looked at objectively, and if the appointor simply in his own mind thinks, if I do X, Y will follow. If X is wrong, if his views about X is wrong, it can't be regarded as an improper purpose. It's just the appointer being misguided.
Well, this isn't a case of being misguided, though, is it?
Well, yeah, maybe. I mean, I'll come on to it. I'm not sure. No, I'm not sure that is the case, because if one looks at it, and we'll come on to this, if one looks at what Mr. Ferguson was saying to shareholders, he fully accepted that if the company repaid the debt, then his strategy of being able to acquire the company, either by offers to shareholders. Well, I mean, if the shareholders accepted, that would be different. But acquire the company as a consequence of a distressed sale would not have succeeded. He fully accepted that.
We'll come to that in due course. But it seems to me at the moment the logic of your argument is that if you are the person seeking to have administrators appointed, it's a statutory scheme. They have the powers that the statute gives them as independent office holders, and therefore your subjective intentions are essentially irrelevant.
Yes.
Because you can only achieve what the statute enables you to achieve.
Yes.
Is that not the logic?
That is the logic, and actually that's one of the arguments we're going to come on to. But yes, it's completely irrelevant what the subjective intentions were. It insulates you, and it may.
But that's an argument that has a logic, and it's right or it's wrong. But let's assume it's right. How does it assist to consider what powers the administrators have after appointment?
Sorry, how does it assist what?
The logic of the argument that you're advancing doesn't seem to me to depend at all upon any investigation of the powers of the administrators.
Well, it does, because
afterwards, other than to say, well, it's what the statute provides.
Yeah, well, it does, because it provides a comparison between a situation where the debenture holder appoints a receiver whose primary duty is to realise assets for the purposes of repaying the debt to the charge holder,
Right, so you say it's germane to your argument to distinguish the position from a receiver?
Yes.
Okay.
Can I just understand that a bit better? Because one way of looking at it is that the administrator's functions are wider than that of a receiver.
Yes, absolutely.
But why does that assist you? Because yes, the administrators have various functions, including seeing whether they could rescue the business, but they also have functions which would clearly include seeking to achieve the best level of repayment they can.
Yes.
In the same way as a receiver. So just help me a little more with why the greater width of the powers and functions of a receiver.
So
yeah, well, you have the point.
Yes, I do. Could we perhaps? I think the easiest way to look at this is to look at the provisions of the Insolvency Act, and in particular, paragraph 3, which is at page 1175 of the bundle. Tab 37.
Yes.
So paragraph 3, Schedule B1, provides that the administrator of a company must perform his functions with the objective of rescuing the company as a going concern or achieving a better result for the company's creditors as a whole than would be likely if the company were wound up without first being in administration, or realising property in order to make a distribution to one or more secured or preferential creditors. Then subparagraph 2, subject to subparagraph 4, the administrator of a company must perform his functions in the interests of the company's creditors as a whole. And then 3, which is important, the administrator must perform his functions with the objective specified in subparagraph 1A, i.e. rescuing the company as a going concern, unless he thinks either that it's not reasonably practicable to achieve that objective, or that the objective specified in subparagraph 1B would achieve a better result for the company's creditors as a whole. And then the 4, the administrator may perform his functions with the objective specified in subparagraph 1C only if he thinks that it's not reasonably practicable to achieve either of the objectives specified in subparagraph 1A and B, and he does not unnecessarily harm the interests of the creditors of the company as a whole. So an administrator's functions are much, much wider than a receiver, and their primary function is to rescue the company as a going concern, which is what they worked with the management of the companies to do in this case. And that is why my Lord Justice Arnold is absolutely right when he says that whatever the purposes a floating charge holder has in relation to the appointment, it's irrelevant, because once the joint administrators, or once administrators are appointed, they are duty bound to follow this statutory scheme, which has as their primary purpose rescuing the company as a going concern. I must say, it creates problems practically for administrators, because on the one hand you have a situation where the management here wanted to effectively put in place a rescue of the company as a going concern, but on the other hand they have to balance that while the company is still trading, so keeping the company still alive, with the risks that the rescue might not materialise.
Explore that a bit further, because the starting point here is the finding of the judge. The company was balance sheet and cash flow solvent.
Yes.
What does rescue of a company that is cash flow and balance sheet solvent mean?
Well, it wasn't. It clearly wasn't cash flow solvent.
Well, the judge found it was.
Well, it's impossible to say. Well, if one assumes that they were paying their debts as they fell due until Niven served a demand for early repayment of the 1.6 million loan, as we say they were entitled to do because they had failed.
So as soon as they accelerated the entirety of the loan, notwithstanding the company was perfectly able to refinance that within a very short period, that resulted in their cash flow insolvency.
Well, yes, it did, and in fact, I mean, what's important to appreciate here is that Niven didn't serve a demand and immediately appoint administrators. They actually, perhaps we should have a look at the correspondence on this.
Well, just before we do that, because the test of cash flow insolvency isn't, as we know, quite as black and white as perhaps it was once thought to be. So you've got to apply a realistic test to whether the company would be able to repay this. This only debt is pressing for payment now within a reasonable space of time. And that's a factual inquiry, if anything. But the judge has said that the company wasn't cash flow insolvent. Aren't we stuck with that?
Well, I think he was meaning it in the context of immediately prior to the service of the demand, because the fact of the matter is, and I think that's why one needs to have a look at the correspondence on this. So you have the letter of demand which we looked at from CMS, which is at tab 31, page 113 of the supplemental bundle. So the demand was made on the 30th of August, and then Mishcon de Rea respond on behalf of Glint Pay Ltd. That's at tab 33 on the 4th of September 2019. And on the second page of that letter, at page 126, we understand that our client is currently in the process of making arrangements to prepay the loan in full. Notice of that prepayment pursuant to clause 6.3 of the facility agreement will follow in due course. If your client's actions are motivated by protection of its legitimate interests, it follows that they should support this commercial solution. The CMS letter requests payment for the sum of at least 1.7 million. In any event, we remind you that it would be unlawful for your client to impose a clog on our client's equity of redemption. And then on the 13th of September, this is at page 129, tab 35. So, over a week later, Mishcon de Rea write again, it also remains the position that our client intends to prepay in full all sums properly due to your client. Clearly this is in the best legitimate interest of your client as well as ours. It is, and then drop a few paragraphs. Well, they say that funding for the above prepayment has been agreed in principle and the parties are engaged in finalising the relevant documentation. And then it's proposed that the funds will be paid into this firm's client account. We will confirm to you when we are in receipt of those funds and transfer the same to your client account. Please confirm that this arrangement is acceptable. Notwithstanding that our client is not in a position to make prepayment today, our client has made real progress and expects to confirm timing for the full prepayment and serve formal notice of prepayment pursuant to clause 6.3 of the facility agreement next week. Now, I'm sure this court will be aware that letters of that kind are written on a regular basis, and in the end, the promised financing doesn't materialise. Now, there are lots of cases which effectively say that once a demand is made, effectively the lender doesn't have to wait any time at all before making an appointment. In this case, the lender waited, the lender's demand was made on the 30th of August, and they didn't appoint until the 19th of September. In circumstances where that was the only information that Niven were given, as to the likely prospects of a refinancing. And remember, this was a fintech company in the early stages of development, and therefore one couldn't say that the loan would necessarily be repaid.
So that sort of, see how that goes to the argument whether there was or was not an improper purpose.
Yeah.
Because a lender who has demanded money and hasn't yet been repaid might be said to be after repayment of their loan.
Yes.
But that's the factual question which the judge has decided against, at least on a arguable basis, decided against you.
Well,
that there was they weren't interested in repayment of their loan. Mm-hmm. They were interested in acquiring the company.
Sorry, that the judge found against that they weren't.
But that's certainly, isn't it right to say that's certainly an arguable proposition sufficient to go to trial, that their intention was not to get repayment of their loan, but to obtain control of the company?
Yes, I think that's probably... well, I think to say that it was their primary purpose, that the evidence suggests that... Well, I do not accept that it was their primary purpose, because the fact that they appointed joint administrators, which wouldn't necessarily result in the repayment of their loan. So I don't accept objectively, I mean, who knows what was going on in their minds, and we will never know, because they're, rather than going off to court and seeking an injunction, immediately the appointment was made, the companies chose, for whatever reason, to allow, Niven, a special purpose vehicle, to go off into the sunset, never to be seen before, and chose to sue my clients. So we'll never know, and a trial is not going to resolve that issue, because the company, still less the administrators, don't know what was going on.
Isn't the relevant person still around, though?
No. What, Mr. Ferguson?
Yes.
Not in this jurisdiction. He's in Singapore, I think.
But he still exists. So
I hope he still exists. Yes, for his sake.
Trials can take place
Yeah.
with people abroad. It's not impossible.
Yes, but you've got to find them and compel their attendance. I think that the main point to focus on is that objectively they must have known that by electing to appoint joint administrators, at most their wish to acquire the business was an aspiration, which may or may not have been fulfilled.
Is this not the crux of the question? Because your submission, which I understand, is you emphasise it's an objective question.
Yes.
Not a question of subjective intent. Whereas Mr. Marshall's argument is subjective intent is the whole question. So what do you rely upon as demonstrating that it's an objective question regardless of the subjective intent of those appointed?
Because if one has a subjective intention to acquire the business of the company, that's irrelevant if objectively there are other purposes that one can look to for appointing administrators.
Sorry, what do you mean by an objective purpose?
Well, objectively in that the loan was undoubtedly due. It assumes the loan was undoubtedly due, and the appointment, that the election to appoint joint administrators would not inevitably produce the result that the appointer wanted.
Sorry, I failed to make my question clear. I apologise. What I was trying to say is both of you are presenting arguments which are logically coherent in their own terms.
Yes.
You say it's an objective question, and I understand why you say that. And Mr. Marshall says it's a subjective question, and I understand why he says that. So my question is, how do we resolve that argument?
Well, I think that's a matter for your lordships, your ladyship.
Well, the conventional way is you either point to some piece of legislation or you point to some piece of case law.
Well, the legislation I will come onto. Frankly, there is no case law in this area dealing with the appointment of a floating charge holder of administrators, where this point has been examined. It has been examined in connection with the appointment of by a charge holder of receivers. But I've already explained to you that is different.
Right. So that seems to be an acknowledgement that this is an area which is free from authority, and what would you say is the proposition that if we're testing the law here, then the better course is to find out what the facts are first before we try and determine what the law is?
Well, no, because I haven't taken you on to the scheme of the Act, which demonstrates, I say conclusively, that there is no role, save perhaps for a vexatious, maliciously exercise of the
so
power.
your submission is straightforward then, it's a question of statutory construction?
Yes.
Okay, yeah. Let's look at the statute.
So, well, first of all, administration is a creature of statute under the Insolvency Act. And I've already explained to you that whereas a mortgagee or a receiver appointed by a mortgagee must act only for the purposes of realising assets to pay off the mortgage debt, an administrator, and we just looked at them at paragraph 3, has far wider powers. The claimant's argument, consistently with the receiver cases, is that if a floating charge holder like Niven appoints the joint administrators for an improper purpose, the appointment is automatically and without more void. Now, that, we say, is entirely in conflict and inconsistent with paragraph 81 of Schedule B2 of the Insolvency Act, which we looked at yesterday. It's in tab 7. 37. My 36, tab 36, page 1181. Page looking at it again. So on the application of a creditor of a company, the court may provide for the appointment of an administrator of the company to cease to have effect at a specified time. An application under this paragraph must allege an improper motive. In the case of an administrator appointed by administration order on the part of the applicant for the order, or in any other case, and we're in B, on the part of the person who appointed the administrator. And then subparagraph 3 sets out a range of orders that the court can make, and particularly D, the discretion is very wide. It can make any order it thinks appropriate. So, including bringing the administration to an end or allowing the administration to continue, which makes perfect sense because if, for example, there was found to be an improper motive, the court could well think, well, even though there was an improper motive, this company is insolvent, or this company is being so badly managed by the existing management, it cries out to come under the control of independent office holders. Now, if the claimant's argument is right, paragraph 81 is completely redundant, because on the claimant's argument, if there is an improper motive, then the appointment is automatically void. So how can a creditor be allowed to come to court and ask for a range of orders, including the possibility that the administration continues, or a counter-argument to the creditor, perhaps, that the administration continues, because it's in the interests of all creditors that it does continue. If the appointment was void, paragraph 81 would have no function. So, as an improper motive is a necessary precondition for an application under paragraph 81, and paragraph 81, by its terms, allows an administration to continue if the court thinks fit. It simply doesn't sit with the proposition that if a floating charge holder has an improper purpose, the appointment is void.
I mean, paragraph 81 would encompass a case where an improper motive existed, wouldn't it? Not
Yes.
The improper motive.
Yes, yes.
Which wouldn't render the appointment automatically void.
Yes.
It's brought by the company.
Yes, yes. And so my learned friend's argument, consistently with the receivership cases, that the appointment is automatically invalid or void, does not apply, we say, in the administration context, for the reasons that I've been advancing, perhaps, that it's a very different animal. It's there, and the joint administrators owe a duty to act in the interests of all creditors, and it's only if the first two purposes, namely one, the survival of the business, the company as a going concern, and two, a better realisation of the company's assets for the benefit of all creditors that would otherwise apply in a winding up. It's only if neither of those two purposes can be achieved that the administrator can go on and actually realise assets for the purposes of making a distribution to the secured creditor.
Can I ask you this question? Is it your submission that on the proper interpretation of paragraph 81, the establishment of an improper motive is a precondition to the making of any order under paragraph 3?
I think one has to look at Artie Brightbar on that, which is at tab 30.
Well, it will be helpful to know what your answer is to the question before we
Well,
look at the authority.
Well, one needs to go to the authority, but the authority says,
We're not bound by it. That's why I would like
Yes.
the answer first. Because it's open to this court, if either party submits, to hold that it's wrong.
Yeah. Well, in my submission, Artie Bright is right in that if one looks at the actual paragraph 81 requirements, the paragraph an application under this paragraph must allege an improper motive, and that is a precondition to making an application. Paragraph 81 doesn't go on to say that the court necessarily must find or make a final conclusion that there was an improper motive. And
so what's the point of requiring the applicant to allege it?
I think the applicant has to adduce sufficient evidence to show that there may well have been an improper motive for the court to be able to invoke its powers under subparagraph 3 without concluding. And the reason why I say that is because you have a creditor here who's charging that the appointment has been made for an improper motive. In the meantime, the company is in total limbo. You've got administrators that have been appointed but don't know whether they can continue to act or not. And the whole point about the fact that the court doesn't have to come to a final conclusion about there being an improper motive is because under subparagraph 3 they have lots of powers to direct certain things.
But on that submission, the effect of paragraph 81 would be exactly the same if one struck out subparagraph 2.
I'm sorry, my lord, I didn't quite hear that.
I said, on that view, paragraph 81 would have exactly the same effect if one struck out subparagraph 2.
Well, no, because I think that one has to at least allege and adduce evidence of an improper motive.
Sorry, where does it say adduce evidence?
Well, if you
allege.
Well, if you allege something, I think. Well, my submission would be that if you allege a matter, it is implicit by saying that you have to allege, that you have to set out the details, the particulars on which you rely to make that allegation, in much the same way as if you, in a pleading, it's not enough just simply to allege that there's a breach of contract. You're expected to set out why you allege that there is a breach of contract.
So we interpret it in that way, fine. I'm still struggling to understand what the point is if it's not a precondition to the making of any order, because, as I say, you could just strike out paragraph 2.
Well, if you struck out paragraph 2, any creditor could just apply to court and say, well, I want this, I want the appointment of administrators to cease to have effect.
On your submission, if I'm a creditor, provided I've got at least some material to support the allegation, I can make an application, I can allege an improper motive, and the court can say, well, Mr. Arnold might have had some evidence to support this allegation, but actually it's obviously bad. And yet they can still make the order. What on earth
No,
is the logic of that?
I think it's, to say it's obviously bad, they wouldn't, the court has a variety of orders that it can make. It can adjourn the hearing conditionally or unconditionally. In those circumstances, the court has a wide discretion as what to do. So they can dismiss the application, they can make an interim order, and they can make any order it thinks fit. So subparagraph 3 gives a wide discretion to the judge in the company's court, hearing the application, to determine how an application of this sort should proceed. Now, if the judge has seen that the creditor has alleged an improper motive, but isn't satisfied that the evidence is sufficiently strong enough for example, to continue the administration, because that is what the ICC judge has in mind, then the court may make further orders for further evidence.
The presumption of innocence, or in this context, the presumption of good faith and regular dealing, square with all of this.
Whose good faith and regular dealing? The appointor?
Yes.
Well, the court, if the creditor hasn't served the application on the appointor, no doubt the court would give directions for the application to be served on the appointor, with an opportunity for the appointor to...
I'm sorry, I failed to make my question clear. I'm really struggling to understand this piece of legislation. That's why I'm asking these questions. So the appointor is presumed to act in good faith unless the contrary is demonstrated on the balance of probabilities. A mere allegation does not demonstrate on the balance of probabilities that the appointor acted otherwise than in good faith and for a proper motive. So what is the point of merely requiring an allegation to be made if the allegation doesn't have to be established? I just don't see the logic of it.
Well, the logic of it is that it permits the circumstances of the administration to come before the court
But if that's all you want, you don't need an allegation of improper motive. If you simply want to give the power to the court to say, is this administration being properly done, then you can do that.
I'm not sure you can, actually.
Well, I mean, as a legislator, I mean, one could do that.
Well, I see. Because the legislation doesn't provide for that. The legislation provides...
Well, that might be a lacuna in the legislation.
Well, that might be, but we're dealing with paragraph 81, and paragraph 81 requires, before a creditor can complain about the existence of a court order or the appointment of an administrator, as the first instance, an improper motive. And then, because of the wide powers that the court has at paragraph 81.3, the court, and it would be typically the expertise of the company's court that would be called upon here. The court can decide what it can do.
All right. But so the bottom line is, I mean, I have to remind myself at this point that this court's function is to decide matters that are in dispute between the parties, not matters they're agreed, no matter how sceptical I may be. But you agree with Mr. Marshall that AIRT is correctly decided?
Yes, I think yes, I think I do.
Right, well, that's fine, in which case we march on. My scepticism notwithstanding.
And it's very difficult because this is not a central element in a sense of the appeal. But the reason why I say it's correctly decided is because the whole point about administration is to try and rescue the company or to get a better result for creditors as a whole. And if an administration is going to be utterly sidetracked by effectively a trial about whether, and for the court to be satisfied on a balance of probabilities that there was an improper motive, then it would completely undermine the function of administration. And I think that is why that's really the reasoning in the Artie Bright case. That's not to say that obviously an ICC judge would not want to be satisfied that the allegation of improper motive was properly made. But I do say that the ICC judge doesn't have to reach a final conclusion.
I apologise for taking up time on this diversion.
Yes, sorry.
But having established that you're ad idem with Mr. Marshall, that AIRT is correct, where do we go from there?
We might want to have a look at Frogmore Estates, which was a judgment of Mr. Marshall.
Fine.
Which is at tab 20 of the authorities bundle. So that we can get the facts from the head note. 3 group companies were granted. Well, perhaps I could just ask you to read the facts in the head note. There was a Comey issue, which is not relevant.
Can I just ask why are we going to this case?
Well, just because it's another case where the court was addressing paragraph 80, paragraph 81. I apologise, and therefore it's just and it's a case where the argument there is that the shareholder in each case alleged that the floating charge holder had been motivated by a wish to stifle or impede the progress of ongoing litigation that the companies had brought against it, challenging its disposal of the loans, its assignment of the loans, and that the floating charge holder had improperly deferred to the views.
But I'm bound to say that reading holding 2 in the head note,
yes,
my scepticism increased, because the conclusion, as I read it, was no improper motive, accordingly no basis to make an order.
Well, and the reason why it was no improper motive was that his motive was not in harmony with that the motive was in harmony with the statutory purpose of administration.
All right. So that's the point you rely on?
Yeah.
Okay.
And then even if the motive was not actually the achievement of a statutory purpose, the motive could not be treated as improper or material for the purposes of that provision, that the court would normally not exercise its discretion under the provision if the statutory purpose of the administration was likely to be achieved, notwithstanding the motives of the appointor. From which right. I glean that the motive of the appointor could be as bad as they could possibly be, but provided that the statutory purpose of the administration was likely to be achieved, the court would not intervene, or at least not intervene in that case.
Okay. Is this paragraph 48 of the judgment?
Yes. Sorry.
Yes, I note the statement is made, the legislation requires improper motive on the part of the appointor to feature for the jurisdiction to be engaged.
Yes.
Here we go.
So I've already addressed you and said that the same principles the principles that apply to mortgagees and receivers do not apply to administrators. So in any event, we say, and really I say that's the beginning and end of the matter, but I'll just go on to say that submit that Niven's purpose has not been demonstrated to be improper, because even if the power to appoint administrators was the subject of a purpose limitation as advanced by the claimants, the mere fact that a party has other purposes in addition to satisfying their debt does not, we say, exercise their power, result in a breach of the purpose limitation. And this is clear from the opinion of the board in Kukurova. If we could just turn that up, that's at tab 13. And if we go to paragraph 78 at page 465, so there the board is saying that referring to the previous paragraph, paragraph 77, CH and CFI do not dispute that ATT appropriated the charge shares in order to satisfy the debt. They hardly could do so, since appropriation is a mode of satisfying the debt. The real complaint is that ATT only wanted to do so because that would enable it to obtain control over CFI and CTH and indirectly of Turkcell, instead of, say, selling the shares onto the market. Since this was the very thing that the contract of the regulations permitted, it's impossible for them to contend that ATT was exercising its power.
Sorry, where are you reading?
Sorry, paragraph 77, the previous paragraph.
I was on 78.
Yes, sorry. Yeah, I did mention 78 and then said let's go back to 77 first. So, since this was the very thing that the contract and regulations permitted, it's impossible for them to contend that ATT was exercising its power of enforcement for a collateral purpose. And I pause there to say that the facility agreement, the guarantee and debenture expressly provided, as one would expect, for the appointment of joint administrators. So we would rely on that to say that the very thing that the guarantee and debenture provided for, namely the appointment of administrators, in those circumstances we say it's equally impossible for the claimants to contend that ATT was exercising, that Niven was exercising its powers for a collateral purpose. The acquisition, looking at paragraph 77, the acquisition of control was a necessary incident of a permitted mode of satisfying the debt. The fact that it was an incident which was highly attractive to ATT does not mean that the right of appropriation was exercised in bad faith. And we say the same applies here, where the guarantee and debenture had an express provision for being able to appoint administrators.
There's no equivalent to the foreclosure provision.
No, there isn't. No, there isn't. No. But just to remind the court of a point that you made yesterday, my lord, of course, the right of a floating charge holder to appoint administrators does not depend on the company being able to pay its debts, being insolvent. It's entitled to appoint if the construction, which it did in this case, the construction of the guarantee and debenture results in a right to appoint, irrespective of any inability to pay debts. Then paragraph 78, the board goes on to say that's enough to decide this particular issue in the case. More generally, however, the board considers that if a chargee enforces his security for the proper purpose of satisfying the debt, the mere fact that he may have additional purposes, however significant, which are collateral to that object, cannot vitiate his enforcement of the security. If the law were otherwise, the result would be that the exercise of the right to enforce the charge for its proper purpose would be indefinitely impeded because of other aspects of the chargee's state of mind, which were by definition irrelevant. And we rely on that, even though it was a mortgagee case, because it cannot be said here that the enforcement wasn't for the purposes, certainly a purpose, of the appointment of the joint administrators. My learned friend points...
Sorry, just...
yes, sorry.
The enforcement wasn't... So
the appointment of the joint administrators.
The appointment was the enforcement.
Yes, I accept that. But what I'm saying is that it cannot be said in this case that the appointment of joint administrators was not for the purpose of satisfying the debt. It might not have been the overriding purpose, but that they were repaid the debt.
Well, can I just understand that? Because does that amount to a submission that, again, there can be no improper purpose? Is it really distinct from your earlier... Because, or are you making a point on these facts?
I thought about this. I thought about this overnight. I can imagine a situation where, be very rare, where the joint administrators are seeking to get the lender to accept repayment of the debt. They repeatedly refuse, and in the meantime, they seek to undermine in some way the efforts that are being made to rescue the company as a going concern, or alternatively, the administrators trying to obtain the best price reasonably obtainable. In other words, they a bit like in I think it was in Cukurova, where the judge found that ATT had press conferences where they'd sort of accused the companies of being hopeless and the management being hopeless.
But as I understand it, you're postulating a scenario in which the appointer has suborned the administrators so that they're not carrying out the proper functions. Well, I mean, I can understand that sort of case might raise interesting questions, but I mean, the argument here is a different one.
Yes, it is, but I'm trying... sorry, my lord, yeah.
So, the argument here is all about what led up to the appointment.
Yes, yeah.
Yeah, I mean, at the moment I'm finding it, given we are at a summary judgment stage, I'm finding this second argument, it had a Niven's purpose at least included securing repayment of the debt, difficult to distinguish from your previous argument.
Well,
unless you could say there is absolutely no evidence, and we've heard from Mr. Marshall, they think there is evidence that the only motive was not securing repayment, but was instead to. Well, there is
the company. There is evidence to the contrary, but I accept that it's a summary judgment application, so I won't go there. But I still hold by the point that I make that the fact that they had this the fact that they had this purpose of acquiring the business. In the context of appointing joint administrators, the court cannot conclude that their only purpose was to acquire the business, because they will have known, or they should have known. I mean, well, objectively, that was not possible.
But you come back to your fundamental proposition, which is it's an objective question and subjective intent is irrelevant.
Yes.
That we understand. But my lady's question is, does Cukurova add anything to that?
No, I don't think it does. And anyway, I'm trying to sort of separate or distance administrations from receiverships, which are different animals.
Yeah.
And I go back to the point that you put to me earlier, Lord Justice Arnold, where you put to me that really our case is that the fact that Niven wished to purchase the business was irrelevant. And yes, we do say that in the context of administration, the fact that a floating charge holder may wish to purchase the claimant's business is irrelevant. And as we say in our skeleton argument, for which the claimants have no answer, if such a desire is improper, if such a purpose is improper, then it would follow that any loan-to-own strategy is improper and void. And yet such strategies are very common. They might be distasteful to the existing management of the companies, but the fact is that commercial funders frequently advance lending to struggling companies in anticipation of being able to acquire the assets out of administration when the companies default. And such strategies are recognised and accepted as methods, vehicles for saving businesses via the new and better resourced owners providing the financial support that the former owners were unable or unwilling to provide. So the claimant's argument that any administration is void where the primary purpose of the appointer is to purchase the business and assets out of administration would, as we say in our skeleton, have alarming consequences both for the concept of pre-pack administration and the private equity market, which is it's common that it's frequently used to keep businesses afloat. We see, so those are my arguments.
Well, it's commonly used in cases of insolvency. That is the classic use of a pre-pack.
Where there is a floating charge holder, because
I understand that a floating charge holder can appoint without insolvency, but that wasn't my point.
Well, I can't. I'm not able to say how often it happens that how often it happens that a company is not insolvent on a balance sheet basis, but a floating charge holder still nevertheless appoints. I have to say, I mean, cynically, in circumstances where the purpose of the floating charge holder is to acquire a business that it rather finds to be attractive, then they are likely to effectively rely on any provision in the lending documents which will entitle them to a point.
Yeah, so in the present case, reliance was placed on the information provision as giving rise to an event of default, giving rise to a right to a point.
Yeah.
And you say, well, that's fine.
Yeah,
that's in accordance with the contractual rights.
Yes.
And the motive is irrelevant.
Yeah, exactly. And this case, and I took you to the documentation. This case was, but I would say it makes no difference if the floating charge holder, if the floating charge actually provides that you can appoint, irrespective of the financial condition of the company. But in this case, as we've seen, the financial condition of the company was parlous. The finances were tight. So, I mean, to the extent that
we don't have any evidence about that. We have a finding of the judge; it wasn't insolvent.
We have. Sorry, if we can just go to the supplemental bundle. Find the right. There is an email from Mr. Cousins to Miss Bakuda where he says himself that finances are tight, and in addition, here we are. It's at tab 32, page 122. Towards the end of the page.
That's not the same as saying insolvent.
No, it's not. But typically.
So where is it?
Sorry, this is 2/3 of the way down.
Which page?
Page 122, tab 32.
Finances are tight.
However, the finances are tight. I've written to you in the last week in our shareholder update newsletters, giving salient features of the present situation.
Well, that's really saying we need more money.
Yes, well, we need more money because...
And they're embarking on a financing round.
Yes, but
that's why companies embark on financing rounds.
Well, it does, but you'll recall I also took you to documents where Ms. Conderer, on behalf of the company, Glint Pay, was saying we are going to prepay.
No, of course.
But yeah. So what I'm saying is that this company was struggling financially. This is from the company's director's own mouth. The loan was a very short-term loan. It was repayable in December 2019, and the floating charge holder exercised its rights in September. In circumstances where, and I have to find the reference, where Mr. Ferguson's view was that the company was going to run out of money in September. I need to find the reference to that.
Whose view? Mr. Ferguson?
Mr. Ferguson, yes.
Well, I'm just concerned that you've been given these statements as if it's an agreed or established fact. These are all very contentious matters on which there was quite substantial evidence from the appellant side. Just by way of example, and it's just one example, one would have regard to Mr. Strong's evidence in paragraph 18 on page 284, where he says that the company was doing very, very well. It's all a matter for trial.
Well, I'm sorry, my lords, my lady, but the document that I just took you to, which I accept isn't conclusive, was one from that Mr. Cousins wrote saying that finances are tight. And I took you to that document, not to show that the company was insolvent, but to show that this was not a company, from the company's own mouth, which was doing fantastically well. The finances were tight. And we know that finances were tight because, in fact, it was Mr. Cousins' company that raised the money to repay the the Niven loan.
All right. I think we need to move on.
Yeah. So dealing with the whether there was an implied term, an implied purpose limitation on the information provisions. So what the claimants say at paragraph 39.3 of the skeleton argument is that applying the principles in Cukurova, there's a purpose limitation on requests made under the information proceedings by reason of the being contained in the guarantee and debenture. And we say that that argument should be rejected out of hand. In Cukurova and the previous decisions that are cited in Cukurova, Quennell and Mortby, which were taken to, and Downsview nominees, they were concerned with enforcement of security, and they weren't concerned with the implication of terms in...
So is it your submission that there was an unfettered right to request information whenever it was so desired?
No. Well, that would be inconsistent with the Property Alliance Group and RBS case, where that, if you recall, was a case where RBS were entitled to call for evaluation, and there was, if we can just go to it, it's at tab 22 of the bundle. And if we could go to paragraph 169 at page 765. Perhaps if we could go back to paragraph 167, and if you could just read down to 169. 167 on page 764. So we rely on paragraph 169, where...
So you accept that in our case 1.11.1 is a power that must be exercised in pursuit of legitimate commercial aims rather than, say, to vex maliciously.
Yes.
Okay.
And it was never...
It's a factual question.
It has not been alleged that those requests were made to vex the companies maliciously. The example that is given in the Property Alliance Group was where the bank asked for evaluation for more than every week or every day. In fact, there was a limit in PAG to once a year, so it didn't really apply, but the example is given in paragraph 167. We can accept that if there is a power to make requests of the sort in paragraph 111.1, that if those requests were made every day for the same information or information of a very, very wide broad categories, and requests were made for the information to be provided.
Sure, as you rightly say, nothing of that kind is alleged.
No.
On the other hand, Mr. Marshall's argument is to say the requests weren't in pursuit of legitimate commercial aims because actually it was done for an ulterior motive. That's the argument.
And in that regard, we say that that has to be wrong because the paragraph 111.1 permits the lender to seek information, and it would have been a very easy matter for the company to have provided that information. And if you have a right of that sort, then it must be read, because it's part and parcel of the guarantee of debenture, as that when you make a request, it is in pursuit of the commercial interests underpinning and underlining the guarantee and debenture.
That seems to be an argument that ulterior motive is irrelevant.
I beg your pardon?
That seems to be an argument that ulterior motive is irrelevant.
I think it's an argument that the court will not inquire into whether there is an ulterior motive, because the provision is there.
But hang on, going back to what Property Alliance actually says, the words in 169 are in pursuit of legitimate commercial aims, rather than say to vex PAG maliciously, suggesting that the court can and should investigate whether there are so-called legitimate commercial aims. How do you determine that in this case? Because the argument against you is would be that a legitimate commercial aim would be to protect the security, the secured assets, the ability to secure repayment of the debt. Not, by the way, the warrants, because they're not secured, as it were. So how do you address that, looking at what Property Alliance actually tells us?
Because if there is a provision in a document which permits a lender to ask for information, then it's implicit, because that's in the document securing assets for a loan. It's implicit that those provisions in and of itself are to further the commercial aim in the guarantee and debenture, and you don't look any further. You don't have to look at whether they are being look into the mind of the lender to see what
so the argument is motive is irrelevant.
Yes.
They have a right to the information.
They have a right to the information, and the reason why I say that is because if that's not the case, then you will always be having debates about whether, when a request is made, it has been made because there is some ulterior motive in the request. The fact that there is no qualification to the right to require information is, I say, a complete answer. There is that the paragraph 111 is not qualified by the requirement that the requests have to be reasonable. It's qualified by the fact that the requests have to concern the secured assets, so they can't be out with that description, but they're not qualified by the term reasonable, and there's no reason why this court should go any further, or any court should go any further. And it would only be in circumstances where, as the court said in Property Alliance, where the requests were being self-evidently made to vex the borrower maliciously, but that's not this case. Those are my submissions.
Thank you very much. Mr. Watts.
My lords, in dealing with the estoppel questions, the way I was proposing to deal with matters is first to address your lordships and your ladyship on the factual matters that we say go to all of the estoppels, and I accept there's a large degree of overlap between them, such that certainly when we get to the end, it may be if I haven't persuaded you higher up the chain, I recognise I may be more difficulty further down. But first I'm going to deal with estoppel by conduct, then estoppel by convention, which is ground 4 of the respondent's notice, then estoppel by deed, ground 6 of the respondent's notice.
Can you enlighten me on this? If you fail on the first 2 ways you put it, how on earth can you succeed on the third?
The only way I could succeed on estoppel by deed is if your lordship considers that detriment. Mr. Marshall's argument is there may need to be some trial on detriment, which is not a requirement of estoppel by deed, but it is a requirement of estoppel by convention.
Right.
I say it is satisfied in any event by the deed, but I accept it. It's a narrow gate that I would need to pass through.
Okay.
And then finally, estoppel by representation. I do accept that if you're not with me on convention, I may have some difficulty on representation. In dealing with each of those points, I'm going to deal first with the way they were put below, i.e. the substance, and then I'm going to deal with my learned friend's pleading objections, which in relation to all of these matters were not taken below, and that's why they don't appear anywhere in the judgment. And just to clear some ground, I have to accept for these purposes that we were not validly appointed, and I also accept that there is a real prospect of it being demonstrated, that in September of 2019 there was a reservation of the position, as Mr. Marshall showed you, and I also accept that there is a real prospect that, as Mr. Cousins says, on the day after the appointment, he raised the fact that the appointment may not be valid with the joint administrators and was told that he would be fired if he raised that again. That's a matter we would contest heavily at trial, but I have to accept it's not something that can be dealt with on a summary judgment basis, albeit what power we would have had to fire if we weren't validly appointed, I don't know. And I'm going to use the language of appointment, but I accept for these purposes it's the alleged appointment. So if I slip into appointment, I mean alleged. So, turning to the background facts, what happened after the appointment, and I don't think we need to turn up the extract, is on the 12th of November 2019, the administrators circulated their proposals. And as your lordship and your ladyship may know, pursuant to paragraph 49 of Schedule B1, the administrators' proposals are to be circulated within 8 weeks of the commencement of the administration. And then, pursuant to paragraph 51, there is to be approval by the creditors by decision procedure, and pursuant to Insolvency Rule 3.36, it is necessary for the proposals to contain details of the administrator's proposed remuneration, both the basis of the remuneration and the anticipated remuneration. And at Rule 3.39, there is provision for a creditors' committee to be formed, but the creditors' committee is only formed at the stage of the proposals, after the proposals are circulated, and here there wasn't a creditors' committee that was formed. And it may be worth turning up in the authorities bundle at page tab 37, 1191, which is Rule 1818.
Sorry, page number again?
1191. So, Rule 1818 says it's for the committee to determine the basis of the remuneration, whether time costs or on a percentage basis. And if the committee fails to determine the basis, or there's no committee, then the basis of the remuneration is fixed by a decision of the creditor by a decision procedure. The problem, however, was that if you go back to Rule 15.2 at page 1187, in relation to a decision procedure at 1188, subpara 2, the decision date has to be not less than 14 days from the delivery of the notice. That applies in administration. And because the proposals were circulated on the 12th of November, and that would mean that the decision date could not happen until the 27th of November, because there needs to be circulation and then the decision procedure, and the administration exit was going to be the 19th or 20th of November. So there simply would not have been time for the approval of the basis of the remuneration to happen by decision procedure or a creditors committee to be formed. And so what happens is if you go to 1192, Rule 18.23 provides for an application to the court to fix the basis. In fact, it says if the base of the administrator's remuneration or liquidator's remuneration is not fixed, then the administrator must apply to the court for it to be fixed. And that is an application that can only be made by an administrator. Can't be made by anybody else. So what the parties did was entered into a waterfall agreement, and it's important to look at the terms of this in some detail. It's at tab 43, page 163. And you can see, even on the front cover, it records Glint Pay Ltd, Glint Pay Services and Glint Pay UK Ltd, all of them recorded as being in administration. And then the companies appear again. And that's because, and I apologise for interrupting my learned friend yesterday, that's because it was signed both by the administrators and by Mr. Cousins as a director. Because, of course, as your lordships know, in administration, the directors don't lose their powers. They can exercise them with the consent of the liquidators, and one can quite understand why it was thought prudent to have both the directors and the administrators sign up to this agreement. And then over the page at 164, we have the recitals, and it's so recital A, the joint administrators were appointed as joint administrators of each of the company on 18th of September 2019, and there's no reservation or qualification to that. And then at C, you can see that it's recited that on the 4th of October 2019, Golden Phoenix entered into administration funding agreement with the companies to provide the joint administrators with the sum of 300,000 for the purpose of discharging administration expenses, the joint administrators' remuneration and capitalised interest. And as we'll come to, there is no suggestion anywhere in this deed that we were not entitled to remuneration. Indeed, if you took the position that we were not entitled to remuneration and administrators, this deed would make no sense. And then at paragraph E, during the course of the administrations of the companies, sufficient funds have been raised and or pledged by or on behalf of each of the companies to satisfy the joint administrators. The statutory purpose of each of the administrations under paragraph 31A of Schedule B1 has been achieved. Consequently, subject to the arrangements and undertakings contained in this agreement, the joint administrators have agreed to vacate office and terminate the administration of the companies by filing notices at court and with the registrar of companies pursuant to paragraph 80 on or before 19th of November. And again, only consistent with us being administrators. And then F, the parties have entered this agreement to confirm and agree the process, procedure and undertakings required for the administration exit, which is defined in E, and for the arrangements that will be implemented immediately thereafter, and record the parties' instructions to their various solicitors. And you can see that the claimant solicitors at 3 were shoesmiths, which we'll see in a moment. And then the operative terms here at 1, the parties further agree, in addition to filing the notices, the joint administrators shall file an application pursuant to Rule 18.23 of the Insolvency Rules for determination and approval of the remuneration expenses during the administrations of each of the companies. And it must follow that it is assumed that the administrators are able to make that application. Again, otherwise the provision makes no sense at all. And then paragraphs 2 to 4 provide that effectively shares would be issued to pay off Golden Phoenix, and 5 to 8, I don't think we need to focus on, deal with the payment of various investors as part of the administration exit, because as part of the waterfall agreement, effectively it's trying to ensure that all of the creditors get paid in order that the statutory purpose is achieved. And then paragraph 9, immediately upon the repayment of the Golden Phoenix agreement, the release of the debenture and various share agreements, Glint Pay Ltd will complete a 2.5 million facility agreement with Stockford Limited. And that, just by way of aside, if you go in the core bundle to page 126 at tab 10, it's the particulars of claim, and you should have paragraph G towards the bottom. It refers to taking out a replacement loan facility as one of the heads of loss. You can see that it's dealing with particulars of loss at 124. There's quite a lot of them. But so that the loan that the claimants were agreeing would be drawn down is what they were agreeing to in the deed. And then turning back to page 166 of the supplemental bundle and the waterfall agreement, paragraph 11 says that upon completion and drawdown of the Stockford loan facility, shoesmiths, on behalf of Glint Pay Ltd and its direction, shall transfer to Jones Day from the amount the sum of 1.567359, representing the amount of remuneration expenses that the joint administrators are or will be claiming in the remuneration application until such time as the remuneration application has been determined by the court. And then over the page, it's held on an undertaking, and it says this undertaking will be provided strictly on the basis that Glint Pay Ltd may not demand return of the remuneration sum until the remuneration applications have been determined. Glint Pay Ltd shall only be entitled to the return of any balance, if any, over and above the sum determined by the court as properly being due and payable to the joint administrators by way of remuneration and expenses. And then at B, there's also payment of the anticipated fees and disbursements of dealing with the application. And again, it's provided on the same. If you look to the very bottom of the page, the sentence beginning Glint Pay Ltd, it's held on precisely the same basis, i.e. they're only entitled to the money that is not found to be due and payable by way of remuneration and expenses. And if we go back in the core bundle to page 125, at tab 10, if you see it E, the very bottom of the page is where it says the first claimant has suffered the loss of sums paid to fund the alleged expenses of the purported administration, and it includes a further 1.57 million or thereabouts paid on around 19th of November 2019. So they're complaining and claiming by way of damages the sum they agreed would be paid, potentially paid to us by way of remuneration and expenses.
What was the payment in the end? What was the remuneration?
The remuneration was that, because that was the estimate. So the amount that was paid over was in accordance with the estimate. ICC Judge Prentice, as I'll show you, fixed the basis and said, well, it's for you to determine the overall amount. And it was that amount, yes. And then, so at paragraph 14, there's an agreement by Mr. This is at page 168, by Mr. Cousins in his personal capacity and as director of each of the companies to release the letters, which are the letters that were written to the court. And then at 15.1, we gave undertakings to file the notices, 15.1.1 and 15.1.2, to file the remuneration applications, and then at 15.1.3 to hold the remuneration sum until determination of the remuneration applications, and it effectively reflects the acknowledgements that we saw earlier. And then if we go to page 170, clause 15.3, the Board of Directors of Glint Pay Ltd, with the consent of the joint administrators, hereby acknowledge and confirm it's provided its irrevocable and unconditional instructions to provide the following undertakings. Immediately serve drawdown of the notice of Stopford loan. 15.3.2, upon completion, to transfer on behalf of Glint Pay to Jones Day the net proceeds, and then to transfer the administration cost. You can see at A and B that were identified before, and then just flicking on to 173, the 15.8.2, the Board of Directors of each of the companies, with the consent of the joint administrators, irrevocably and unconditionally acknowledge and accept that while Jones Day will hold the two sums, effectively Glint Pay Ltd will only be entitled to any surplus. It won't have any entitlement to anything else. And then at 174, you've got the standard provision at paragraph 18 in relation to the joint administrators, in relation to personal liability 18.1, and at 18.3, the provisions of this clause shall continue for the benefit of the joint administrators, notwithstanding that the joint administrators will cease to act as office holders in respect of the companies upon the occurrence of the administration exit. And then at 18.4, the administrators consent to the Board of Directors implementing the agreement. And as we saw yesterday, at 176, it was signed by Mr. Baker as administrator, and then at 178, it was executed by Glint Pay Ltd in administration, acting by Jason Cousins, one of its directors. I'm going to show you how this developed before I see Judge Prentice, before I come to the test, but I will be saying, if you are, there's no reservation at all in this deed about the validity of the appointment, and I do say, if you are were contending that the administrators were not administrators and were not validly appointed, you could not possibly have signed a deed in these terms. Its terms just don't work. Because the deed is premised on, one, that we are in administration and are going to come out of it, two, that we are entitled to remuneration as administrators, and therefore, three, that this is the means for dealing with those facts. So, can I turn then to the letters that were annexed to the waterfall agreement and provided to the court? They appear at page 207. And I know we looked at these yesterday, but they are quite important. So these are to be written by each of the companies. They're in similar form. Each company writes one. Mr. Cousins and Mr. Fukuda also write one in their personal capacity, and Golden Phoenix, as the secured lender, write one. And at paragraph 1, it said that Niven appointed Jason Baker and Jeff Rowley of FRP as joint administrators of the company without any reservation at all. And then paragraph 2 on, and there's a date to be filled in, each of the companies exited administration as a going concern. And again, if your position was that they were not in administration, those two statements could not be made. And then it says GPL is a future creditor of GP UK in respect of an intercompany loan of 9 million, not currently due, may fall due in the future. We understand that the costs of the company's administrations will be determined by way of the court application or otherwise in accordance with the insolvency rules. And then 4, we hereby confirm that GPL, in its capacity as a future creditor of GP UK, will not object to the former joint administrator's fees and remuneration incurred in relation to the administration up to week 10 as set out in the fee estimate. So that's the point that it was transferred. We also agree that the basis of the former joint administrator's fees and remuneration be fixed on a time cost basis by reference to time properly spent by the joint administrator and the staff in attending to matters in administration pursuant to Rule 18.16.2 of the 2016 rules. So it's a non-objection to the amount of the fees and a positive agreement to the basis of remuneration of administrators, qua administrators. Obviously, there is nothing in this letter which reserves the position or suggests there's any doubt as to the validity of appointment or suggests that we're not appointed. The only sensible way I submit that you can read this letter is, again, that there are administrators who have been appointed, are coming out of administration, and that the person writing it agrees that they should be remunerated on a particular basis and doesn't object to the amount. And so these letters were, and the waterfall agreement was very important to both sides because it's obviously, it facilitates the claimants getting their company back quicker than one would do if there was a decision procedure or if we had to go down the route of a creditors committee. We agreed to make the applications and come out of administration early. But it's also very important, the letters are also very important for us because the one question that one is always asked on a remuneration application is, well, what do the stakeholders think? What do the creditors and the contributories think about your remuneration? And do they have any objection to it? So if I can turn then at page 221 to the application before ICC Judge Prentice. And so we have the transcript at 221. And obviously, it's said to be in the matter of Glint Pay Ltd. It was an application in the matter of all three companies. I think everybody just dealt with Glint Pay because they were the first company, and everything seemed to follow from the others. But and also I should note that Mr. Spooner is named as a respondent in the transcript. He wasn't actually a respondent to the application. The application did not. It was an Insolvency Act originating application notice. It didn't have formal respondents. It had notified parties, and Glint, the companies, were notified of the application, and were also notified of the fact that originally the hearing was listed for the 23rd of January, and it was brought forward to the 6th of December, and they were notified of that as well. And that was all common ground before the judge. So if one goes then at page 225, there had been a discussion initially by Mr. Spooner, by Mr. Parfitt on behalf of Mr. Spooner, seeking an adjournment. And at C, I say there's an administration remuneration to be fixed on a time cost basis, and there's a cap. And I say an adjournment's not appropriate at E, and then at F, in resisting an adjournment, I say this is an application made by a 0.6% shareholder of Glint Pay Ltd. Don't understand the basis. They have standing to challenge in relation to the other two companies. Even if that was not right, no weight could possibly be attached to this in circumstances where you have a solvent rescue, where there's not been time to form a creditors committee and have the decision. And the judge says, I need to understand why you need to make the application. And so the point is this: given the approvals that we have already obtained, i.e. the letters, we would have obtained that approval. So essentially, we're being penalised for having come out of administration too quickly. And if somebody wants to receive an adjournment, it's incumbent to say something more than the absolute figure seem a little high. So the point being made is you should deal with this because, look, all of the principal parties, i.e. the claimants, have agreed to this because...
Sorry, just to be clear, the approvals that would have been needed would have been a creditor approval.
Well, the claimants were the creditors.
I realise that.
Yeah.
They clearly weren't the only creditors. Those letters that you show us refer to their role as creditor of one or other of the other companies.
But all the other creditors were paid out as part of the waterfall agreement. So the point was they were the remaining parties who, once the waterfall agreement had been put into effect, they were the remaining parties who could be essentially able to object at all. Once the other creditors get paid as a result of the waterfall agreement, the remaining creditors, and indeed, if there are then no creditors, the contributories have an interest, but it's the claimants. And in fairness, Golden Phoenix then becomes the shareholder, and Mr. Cozens and Miss Fukuda in their personal capacity. But they were the interested parties, effectively.
The only people not paid on exit were the insiders.
Yes. That's my understanding. And then the adjournment application is dealt with effectively by an extension to the time for us to obtain our discharge. And then if one goes to 228 E, we get to the main applications. I noted at G that this was the subject of a solvent rescue, and it's A over the page, 229. So as you've seen, the majority of the shareholders, and by far away the majority of the creditors, including the only secured creditor, are content with the application. So the starting point would be that had we been in administration a little longer, we'd been able to go down the route of a creditors committee or similar procedure, and we would have succeeded. We've been forced into making this application because the company's exited too early. And then I talk about the justification for the work done, because under the practice direction, even where you're just trying to fix the basis, you have to provide effectively 20 categories of information. It's a very, very onerous application to make. In fact, I just want to be clear. If one goes to page 230 in answer to my Lord Justice Zacaroli's question, I said that they'd all been paid. I think there was one tiny creditor who might not have been paid, and that's why I'd said the overwhelming majority. I think there was some doubt about a very small creditor. I can't for the moment. But it doesn't matter though, because
so that's what you say at A to B.
Yes, exactly. And then if one goes to the judgment at 235, the judgment notes at paragraph 1 that we made the application. At the time of the application, we were the joint administrators of Glint Pay Ltd, UK Limited, and Glint Pay Services, albeit that we then filed notices terminating after we'd made the application. At paragraph 3, it's noted that it was Niven on the 18th September appointed Mr Baker and Mr Rowley in its guise as qualifying floating charge holder. And then it explains the reason why the applications were brought forward. And at 4, he notes plainly the applicants are within Rule 1823 of the 2016 insolvency rules, in that there has been on this timescale no opportunity for creditors to approval. And then at 5 over the page, he says it's very difficult to think any basis other than time costs could be appropriate in basis of a case within his rescue. There's nothing obvious which anything could be produced. It's plain that substantial work had to be carried out. And then he says it's plain as well that the tasks performed by these administrators fall outside what may be described as usual administrators' tasks, by which I mean they are tasks for particular specialists within their field. As Mr Watson points out to me, given that this application is supported by the only secured creditor, as well as by Mr Cousins as the largest shareholder, had this matter gone to a vote, then this is exactly the basis that would have been approved. So at least one part of the judge's reasoning in coming to his decision is that this would have been approved, and the only basis that he had for making that statement was the letters that were written by the claimants. There was nothing else. And so, as we're going to come to on Estoppel by conduct, if the touchstone is whether the court was misled, then the letters were, on the appellant's case, misleading, because they informed the judge that the administrators were appointed entitled to remuneration, and that they agreed to the 1823 application, which could only be made by administrators. And actually, just for completeness, at page 239, at tab 46, just to see the orders that he made. Well, yeah, sorry, 238. You can see he makes it. It is recited upon the application as former joint administrators, and then he fixes the time cost basis, and at 1 base the remuneration, and just to be clear, the reason why it says 485 is because there were 3 companies, so the total comes to the 1.57 figure. So this is just one of the this is one of the 3 orders, and then paragraph 2, pursuant to paragraph 98 of Schedule B1, the administrators and each of them discharged from liability. And so he has no jurisdiction. If we're not appointed, he's got no jurisdiction to make the order under paragraph 1. He's got no jurisdiction to make the order under paragraph 2. And paragraph 3, the administrator's costs and incidental of this application shall be paid as an expense in the administration of the company. He's also got no jurisdiction to make that order because there is no administration.
None of those orders were made in favour of, in any way, companies, were they? They're all orders which favour the administrators. They're getting something out of this, and no one else. Is that fair?
I don't entirely accept that. I accept that plainly we've got to fix the remuneration, so it favours us in that sense. As we're going to come to, the administrators didn't then get the money and keep it. They paid it out to various parties. But I accept it's a favourable order for the administrators.
The only thing the court is ordering is 3 things. Each of them is for the benefit of the administrators. Their remuneration is fixed, they get their discharge, and they get their costs.
Yes, but
nothing else. Yes,
I agree with that. So can I turn then to the law on estoppel by conduct? We can start with the decision in LA Micro, which is at tab 27 at page 914, which we looked at yesterday. And this was a claim, as your lordship may know, it's slightly complicated facts which probably don't matter, but essentially it was a claim concerning the ownership of a company, where it was argued by Mr. Bell that he and another person were joint owners, and it was resisted on the basis that an inconsistent stance had supposedly been taken, and His Honour Judge Jarman had found that the individual had been confused, and so no unequivocal stance had been taken. We can... it's really the discussion of the law that matters, and it's page 922. Paragraph 19, it cites the statement of Viscount Radcliffe that a litigant may be shown to have acted positively in the face of the court, making an election and procuring it from it an order affecting others apart from himself in such circumstances that the court has no option but to hold him to his conduct and refuse to start again on the basis that he has abandoned. And then there's the statement in Gandhi and Gandhi.
Just pausing there. Did the companies procure an order?
Well, by their letters to the court. As I'm going to come to, there's a question about...
They acquiesced in an order being made, but did they procure an order?
Well, I'm going to come to, because in the judgment in Malik and Malik of the Lord Justice Zacaroli, the question of whether it needs to be but-for causation was canvassed, and the decision was that it doesn't. And I say for very good reason. But in any event, I do also say that the reasoning of His Honour Judge of ICC Judge Prentice was that, in part, the approvals would have been obtained had this gone to a creditors committee, and that was not whether you say it was procured or not. The point is that that only came about because of the claimants agreeing to write a letter to be provided to the court that made that position good. So certainly his reasoning was procured in part by the claimant's actions.
Well, there may be a difference between the concept of causation, which is what you're on, and I think what my lord was asking about, which was procuring something. So it rather links to the question I was asking earlier. The companies got nothing from these orders. The orders are all in favour of the 3 matters ordered are all in favour of the administrators, not in favour of the companies. There's no order that gives the company anything. The companies anything.
Well, I don't accept that that's the test for it. I accept that in most ordinary ways of looking at it, yes, we benefit and the companies don't. Say that obviously fixing the basis of the remuneration gives some clarity to everybody about how we're to be remunerated. Similarly, our discharge, there is a period for discharge that gives clarity to the parties, and indeed the claimants then made an application before the discharge period had ended, and there was a dispute about whether or not they were able to do that. So I accept that it is in part for the benefit of the administrators, but it is an order of the court that gives clarity to all parties as to their legal rights and entitlements. And so the administrators similarly can't come back and say, well, we want to be paid more, we want to increase our estimate, or we want a discharge earlier. The point is that if there's objection to be taken, what I'm saying is you can't write to the court on one basis to say we don't object and we agree, and then turn around and sue us on the basis that those orders effectively should never have been made.
But on that remuneration point, all the order does is fix the basis of remuneration. Or does it go further? Does the figure?
It fixes and it caps it.
It caps it, right?
And there might be there would be an interesting question as to if the claimants had kept perfectly silent. It'd be very difficult for me to say anything. But the point is where you enter into the arena, as it were, where you write to knowing that it's going to be provided to the court, that's where you move from simply non-objection to active participation. And so paragraph 20, it deals with Gandhi and Gandhi, and the statement of Lord Justice Bowen at paragraph 21 that having taken advantage of one construction to then take advantage of another will be a monstrous injustice. Admittedly, I accept they succeeded on the footing, so it was their application. Here, I accept this wasn't the company's application. But I do pray it is playing fast and loose with with justice if the court allows parties to do that. Because I should also note, the order of ICC Judge Prentice, there never been any application set aside on the basis that it was wrongly made. And then at 22, it says the phrases used in these cases suggests not every change of position which will create this form of estoppel by a party or a witness which will create this form of estoppel. So it doesn't just apply to sort of the applicants and active parties. Radcliffe's formulation requires that the party stance in the early proceedings was that means by which it procured an order. Circumstances must be such that the court has no option but to hold him to his former stance. And then it goes on in that paragraph at B to say these phrases suggest it must be apparent from the earlier judgment that the stance taken by the party was a reason for the judgment which he obtained, and that it would in all circumstances...
So again, looking at that paragraph, the companies didn't procure an order and they didn't obtain a judgment.
Well, they materially contributed to it.
You say
they were notified... Yes, I do.
Okay.
Because one could quite see that you might have a situation where an order comes about that neither party is actively seeking, but is formulated on the basis of the party's various positions. And in those circumstances, it can't be right to say, well, because you didn't procure it, because you didn't get exactly what you wanted, you're held to it. You're not held to what you've said before. And here, the point is that having positively agreed to an order, to at least part of an order, that the court would have no jurisdiction to make if the appellants are right in their present case, they can't now turn around and make that case that we're invalidly appointed. And then it deals with the New Hampshire and Maine decision, the facts which don't matter, but it cites the statements of Justice Ginsburg, said, where a party assumes a certain position in a legal proceeding and succeeds in maintaining that position, he may not thereafter, simply because his interests have changed, assume a contrary position, especially if it be to the prejudice of the party who's acquiesced in the position formerly taken by him. the purpose of the rule was said to be to protect the integrity of the judicial process by prohibiting parties from deliberately changing positions according to the agencies of the moment and preventing parties from playing fast and loose with the court. And then it says, first, a party's latter position must be clearly inconsistent with its earlier position. And secondly, the court may inquire whether the party succeeded in persuading the court to accept the party's earlier position, so that judicial acceptance of an inconsistent position in later proceedings would create the perception that either the first or the second court was misled.
So, did the companies succeed in persuading Judge Prentice to accept the validity of the appointment of the administrator?
Well, he has to have been persuaded that we were administrators in order to make an order under Rule 1823.
He assumed they were administrators in the absence of any challenge.
Yes, and that was materially contributed to by the fact that letters were written by the creditors, i.e. the claimants, saying that they agreed to the order, which carries with it the suggestion that the court must have jurisdiction to make it. There's no other way you could possibly understand it, I submit. And I should note, of course, one of the very heads of loss that are being claimed in these proceedings is the remuneration. So, at the very least, one court must be being misled on this hypothesis. Either the first court would have been misled in ordering that the administrators were entitled to remuneration on that basis, or the second court in finding that we weren't. That's applying the test in New Hampshire. And then he goes on to say, the authors of Spencer Bower consider there's no reason to suppose the law of England is different to the law of the United States. No parties to this appeal suggested that this is wrong, and I agree. It's clear this form of estoppel by conduct is one which is approached by means of broad-based merit assessment and is not constrained by strict rules, as for example issue estoppel. It's material to ask the question of whether it's apparent the early decision was obtained on the footing of or because of the stance taken by the party in the early proceedings, and I say that is clearly the case here. Absent that factor, while the change of position may affect the credibility or witness concern, there'll not be an impression that one or other of those court was misled into giving its decision, so that the administration of justice risks being brought into disrepute. So the touchstone is whether it looks as though the court was misled, and I say that if the appellants are right and we were invalidly appointed and they bringing this claim, ICC Judge Prentice was misled by their statements.
Why?
Because
I don't follow that, because it's commonplace for a court to make an order based on an assumption which subsequently turns out to be correct, and therefore the order is set aside. It doesn't mean the court's been misled. It means it's acted on the basis of an assumption which is subsequently turns out to be incorrect.
Well, I suspect if one applied to set aside the order if the claimants had applied to set aside the order of ICC Judge Prentice, which they presumably must do if it said we've got no entitlement to if they're entitled to recover the remuneration because we're invalidly appointed.
Well, it's an interesting forensic point you make there, but as I understand it, you don't say that they are debarred simply because they haven't set aside Prentice's order.
No, I say they're stopped by conduct because they wrote to the court, and that was a material factor in bringing that about.
So apart from the forensic point, what's the relevance of the fact that they didn't apply to set aside the order?
Well, what I was going to say is that if they applied to set aside the order of ICC Judge Prentice, one anticipates they would have quite a lot of explaining to do as to why they had written to the court to say that they agreed to that order.
Well, their explanation would be the one Mr. Marshall gives, which of course remains to be tested, but they say that they agreed to it because they had no alternative, commercially speaking, and they had already reserved their rights to challenge the validity of the appointment.
Well, there are two problems with that. All of their claims about having no option are inconsistent with the suggestion that we were invalidly appointed, because all the points about we needed to procure the end of the administration early, we were threatened with being fired, presupposes the administrators have got power to do that, and they don't on this hypothesis.
Well, That's a bit unreal in the real world, isn't it?
Well,
I
no.
mean,
Because
the point is you're faced with a situation where the administrators are actually there, and the question of validity would always only be tested a long time down the road.
no, ordinarily you apply for an injunction. What normally happens is there's an injunction either to prevent the appointment of administrators, or an injunction to prevent, or an injunction to restrain them from acting, or a paragraph 81 application. That's exactly the kind of application that one would anticipate to be made in very short order.
Had they refused to play ball on remuneration because the companies, because they took the view that there was an improper appointment, what would the practical consequence have been? The administration would have carried on for a number of more weeks before that matter could. I mean, it could have been a long time before that was resolved. You need a trial to resolve the question of improper purpose.
Yes, they presumably would have. I mean, there are two consequences. I think there would have had to be some form of application to court for directions and potentially a trial either in short order or a long way down the road, whether that would have been expedited or not.
The administration carries on in the meantime.
The administration carries on in the meantime.
Incurring more costs.
But there's
Incurring more costs.
If we're validly appointed, yes.
Well, even if not validly appointed, in the meantime, whilst the matter is unresolved, the administrators are going to be working. They'd have to.
Yeah.
And they're going to charge for that.
Yes, although the question of whether or not they're entitled to charge the claimants for it. The only point I'm making is that they can't charge the claimants for it if they're not validly appointed.
No, but at this stage, the company is faced with fees of over £1.5 million, which if they turn out to be wrong about the improper purpose of appointment, they're going to have to pay, or they're going to have to bear the cost of. That risk of incurring even greater costs is carrying on day by day that the administration continues.
Well, exactly. I mean, I may be misunderstanding, but I say that's a point which falls on my side.
It raises the question of choice. Yes, they have the choice to have brought proceedings and let things carry on for some, perhaps months, maybe the fees increasing quite dramatically over the course of that year. Or we can stop the flow of funds now, which are completely unnecessary, they would say, because these companies are trading perfectly solvently, by just ensuring they get out now and stop running up the costs. It's a choice, but it's one which is one of the options. It's not a gun to the head, but it's a lot of money.
It is. It's an economic choice that you have to make. I say you can't enter into the deed that provides for the remuneration applications to be dealt with and provides for the waterfall, and then write to the court to support those applications.
So your argument is straightforward. You say these are inconsistent positions. They have to choose. They did choose.
Exactly.
But would you accept the converse, which is if we come to the conclusion, and I say if, that they're not in fact consistent positions between which they had to irrevocably elect one way or the other, then the argument falls apart.
I think they have to be inconsistent. Yes.
Yeah.
Yes, I accept that the positions have to be inconsistent.
So if it is permissible to pay under protest, then that's the end of the argument. I say if.
No, because there needs to be an order fixing the basis of the remuneration. So it's not something that can be done under protest.
So you can't do it under protest?
No.
Okay.
No, you can't. There has to be an order that has to be made on the application of administrators. And so you can't say, well, under protest. I suppose they could potentially have handed over the money and said, we're giving you this money under protest, but there then would have had to be an application of a fundamentally different
as I understand what you've just submitted, it would have made no difference to your argument if the waterfall agreement had contained an express reservation of rights, because you would say, well, you can't do that. It would be writ on water.
I'm sorry, I'm just taking a moment to understand that if there had been a reservation...
You just told me you can't pay under protest.
Yeah.
And if that's right, it would make no difference if it was written into the agreement.
Well, I suppose it would make it could make a difference to the order that the approach the court would take on the remuneration application, because if it was written into the agreement that we're saying this, but with a reservation that we don't actually accept that it is that the administrators are validly appointed, plainly any administrator would need to draw that to the attention of the court in making its order fixing the basis, because rule 1823 is mandatory that you have to make the application to fix the basis.
To be sure.
So if that was,
but what I'm trying to understand is the logic of the argument, because I perfectly understand your submission. You have to do one thing or the other. You can't pay under protest. That's perfectly logical. But pursuing that logic through, that means it makes no difference if you write it into the waterfall agreement, and it would make no difference if it was drawn to the ICC judge's attention.
well, if it had been drawn to the attention, suppose they've made a reservation that says we accept this application. We don't object to it, but we don't accept that you were validly appointed, and therefore we say you're intermeddlers and trespassers, and so it's with that reservation. The ICC judge is then going to need to be satisfied that he has jurisdiction to make the order.
But why? That's what I don't understand.
Because it's not a matter of concession, it's a matter of jurisdiction. That he only has jurisdiction if they're administrators.
Let's imagine to pursue the hypothetical. So the waterfall agreement contains a recital that says the companies have reserved the right in future to challenge the validity of the administration. That is then drawn to the ICC judge's attention. What's he going to do? Because all he's seen is a reservation. There is no present challenge to the validity of the appointment. So why does he not go ahead and make the order and say, okay, well, if and when validity is challenged, then that will have to be sorted out down the line?
Well, because he would say, I need to be satisfied that I'm actually entitled to make this order. And he might accept the submission.
So that seems to be a proposition that any ICC judge receiving one of these 1823 applications has to require into the validity of the appointment. He can't simply assume it unless it's challenged.
Well, no, but if you've got a document that says I reserve the right to challenge the validity of the appointment, then the judge usually will assume it. But if he's got something like that, he's obviously going to think, well, he's going to want to be satisfied. Well, what's the basis of that reservation? It'd be quite surprising that the ICC judge doesn't want to.
This is where I'm really struggling to understand the argument, and I apologise for interrupting. Let me try it one more time. What is the judge supposed to do if he simply sees a reservation of rights but no present challenge? Is he submitting that he would then refuse the application on the basis that there's a reservation of rights?
I'd be surprised if he would. What one would normally expect is he would ask of the applicant before him, well, what's the basis of this? And the applicant will probably submit, well, there's a reservation of rights, but it doesn't really go anywhere. There's no present challenge. We were appointed. Here's the appointment. And the judge would probably then deal with the matter by way of a judgment and say, well, there is this reservation and I'm satisfied on the material before me that I have jurisdiction to make the order. In the way that the court often will say, well, I've considered the question of whether I have jurisdiction. And usually where there's no challenge at all, there's no mention of any challenge, yes, it will be assumed. But if there was an express reservation, effectively highlighting that there might be an issue about it, the ICC judge might consider it and give a judgment. But in a way, I'm struggling to answer your lordship's question because I don't know what ICC Judge Prentice would have done because
it's
they didn't do this.
Yeah, sure.
Would it be open to an ICC judge in the knowledge that there was a claim made by someone who's not in fact in front of the court that not a party to the proceedings that the administration was improperly commenced? Would it be open to the judge in those circumstances to record that in a recital and say, on the footing that I have jurisdiction, this is the order I make?
I can't see how he could, because unless he is satisfied that he has jurisdiction to make it, he can't make the order. And the only analogy, the only time, and I'm afraid I'm going to give evidence about this, the only time I've ever seen this come up is when you make administration extension applications. So administration lasts for a year, and what happens is you apply for the judge nowadays by telephone hearing, and the district judge will usually take you through in quite some detail the appointment and the various extensions to be satisfied that they have jurisdiction to make the order. So it may well be that the judge could have dealt with it in all kinds of ways. I struggle to answer because it is hyper.
That's very understandable. Can I ask a different but related question? When we speak of courts having jurisdiction, that expression is used in a number of different senses. It's not necessary for present purposes to go through all of them, but I want to distinguish between two senses in which it's used. One is, does it have jurisdiction as a matter of pure abstract law? The other is, does it have jurisdiction in the sense that the necessary factual prerequisites for the exercise of a power have been established? Now, would you accept that in the present case we're in the second scenario? There's no question of any legal limitation on the court's power. The question is one of the factual prerequisites. And is it not commonplace for courts to exercise jurisdiction on an assumption as to factual prerequisites having been established if there's no challenge to those factual prerequisites?
I wouldn't characterise it as an assumption that if there is a necessary part of an order being made, what the court does is it doesn't make an express finding. I accept that. It doesn't make an express finding in a judgment, but I don't accept it's characterised as an assumption because it's a prerequisite of making the order.
For this reason, I mean, if it's a pure abstract question of law, jurisdiction cannot be conferred by consent. The court has a duty to inquire as to whether it legally has the power to do that which it is being asked to do. By contrast, it's not the function of the court, it's not an investigatory tribunal, so it's not the court's function to go out investigating facts which may be necessary prerequisites. Therefore, if an application is made, the court assumes the necessary factual prerequisites in the absence of any challenge.
I'm slightly struggling with the distinction. I'm so sorry. It's probably me being very slow. But the way I submit it works is I accept it's certainly the second limb. That is definitely the case. But I also say in order to make the order, there has to be an application by an administrator.
Well, indeed. But I think maybe just put a bit of flesh on the bones. In the ordinary course, that application would say, well, administrators were appointed on X date by floating charge holder, and nothing more is said. It's at least implicitly assumed that there was an event of default, the circumstances have arisen and so on, and therefore that no one is gainsaying that statement that the administrators were appointed. It's really no more than that. That must be done daily or regularly by ICC judges. They are not investigating into things that are not before them. That's not a judicial function.
No, I quite accept that. I suppose the way I would characterise it, and I'm sorry that it's me not being clear, that the way I would characterise it, I just don't. The only issue I take issue with is the question of whether it's just an assumption, or the fact is that.
Well, you can choose your word, but it is, in the particular scenario I've given, the judge is indeed assuming that what he's been told is accurate.
Quite. But I suppose that dealing with it solely as an assumption says that it's necessarily provisional, and I say it can't be solely a sort of provisional basis for making an order, because it is a fundamental part. It's just that the court says, well, I don't need to be satisfied on this question because there's nothing to gainsay. That's my submission.
Okay, thank you for your patience in answering our questions. Have we finished with LA Micro?
We finished with LA Micro. I can deal very quickly with Malik and Malik, which is rather odd. It starts at page 1046 of the bundle, tab 32, and very odd facts involving a possession proceedings issued in 1987, which was stayed following failure to pay security for costs, and then the mandatory stay in the CPR, and then an application in 2011 to lift the stay, which was refused on the basis that a litigant said he didn't have an adverse possession claim, and then when possession proceedings were later brought, the litigants tried to say that he did have an adverse possession claim. And the discussion of the law starts at 1052, and those are the passages from LA Micro at 32 and 33 that we saw earlier. And then there was a submission by Mr. Mumby that there were various other authorities that needed to be considered, and at paragraph 35, Lord Justice Zacaroli notes that it's a broad-based approach, and at 36 he says the form of estoppel by conduct in issue can regularly be seen as a species of abusive process, and then at 37 it's noted that where a first instance decision consists of an evaluative judgment based on the balancing of factors, then Aldi Stores applies, and it will only interfere when the judge is taking into account immaterial factors, and if to take account of material factors erred in principle or come to a conclusion that was impermissible or not open to him. And then it's again at 38 reiterated that this is a multifactorial assessment. And if one then goes at paragraph 55 at page 1059, it's said that Mrs. Justice Bacon's, Mr. Mumby's submission that Mrs. Justice Bacon was wrong, that there needed to be a clear and unambiguous representation, paragraph 55, that instead what's needed to be shown is a clear inconsistency, and at paragraph 60, in contrast, Mr. Jordan submitted the need for a clear statement arises from the requirement that the party's position must be clearly inconsistent, bolstered by a close analogy with promissory estoppel, and that's rejected at 61. It says it was made clear in LA Micro this form of estoppel by conduct is approached by means of broad merits-based assessment and not constrained by strict rules. And then at 63, there's no reason to impose a further requirement of an objectively unequivocal statement. And at the end of 63, it's sufficient to demonstrate a clearly inconsistent position. And then at 66, stated that His Honour Judge Gerald found that Bacar's statement brought about or strongly influenced Mr. Jarvis QC's decision. And Mrs. Justice Bacon had held that it was a material reason and sufficient to engage the principle, and rejected the contention that it needed to be a but-for cause. And then there was various decision of whether, essentially, that this was the only decision that Mr. Jarvis QC, who was the judge, could have made, and that is ultimately rejected at 78 to say not satisfy the only decision Mr. Jarvis QC could have reached, even without Bacar having taken the position he did, was to refuse to lift the stay. So the point being made there was, well, effectively this would have made no difference, and the question is, the position I say is, does it influence the judge, or is it part of his reasoning? Not, you don't have to go onto a sort of but-for inquiry as to whether or not the judge would have made the, in the hypothetical world, would have made the order anyway. And then just finally, before the short adjournment, the case of First National Bank and Walker, which is at tab 6, page 65.
I beg your pardon, could we give me the tab again?
It's tab 6, I'm so sorry.
Thank you.
And this was a case, you can see the issues at paragraph 1 of the Vice-Chancellor's decision. In effect, Mr. and Mrs. Walker they charged their home in 1991, and in 1993 the marriage had broken down. At paragraphs 5 and 6, she referred to the charge in an affidavit in the matrimonial proceedings, stating that her home was at risk, and a property adjustment order was made at paragraph 7. And then at the matrimonial proceedings were then partially compromised at paragraph 14 by way of a conveyance, which recited the existence of the charge. But then when it came to deal with the bank's application for possession, at paragraph 19, she averred that the execution of the agreement and the charge had been procured by undue influence. And the discussion of the law begins at paragraph 42 on page 74. Where it said, parties to proceedings is required to be consistent to some degree, and notes there are many decisions to that effect. And then the passage I would draw to your Lordship's attention is at page 76, paragraph 44. The statement of Lord Justice Brown-Wilkinson that wife was confronted with two alternative and mutually exclusive courses of action, choice of which would either substantially affect her financial position and the husband's. She could embark on a misfeasance action, which would probably delay the outcome of her application for financial provision in the matrimonial proceedings pending trial the action, or result in her getting no lump sum. Or she could proceed with that application, which was then at stage of hearing, on the basis that the conduct would remain unchallenged, and her shares in CHM were consequently valueless. But she could not, in my opinion, do what she sought to do, which in this case, which is pursue both courses. And
so you rely on this as supporting your submission that it wasn't possible to pay under protest?
Yes. Yeah, exactly.
All right. Is that a convenient moment?
It is.
We'll resume at 2 o'clock.